Good evening. This is John Milburn for Laws 11057 and Laws 11059. Tonight is a special combined session. Part of the reason for this is that from time to time, I do like combined classes. It gives people an opportunity to see others that are in the group. So please take the opportunity to make yourself known. If you like, take the camera off, and if you wish, show us where you are, and you can use the chat facility, and you can certainly unmute your microphone. All right, so I'll be alternating between gallery view and speaker view as we proceed tonight. The other reason that I like to have a bit of a different class on an evening such as this is that for those of you doing statutory interpretation, you have an assignment due tonight, and I've got to be very careful not to provide you with specific content that might be used in that assignment. It creates an unfairness situation. So there's a couple of reasons why I wanted to have the combined session tonight. So firstly, for those of you doing Introduction to Law, your first assessment overall was great. I'm really pleased that people were able to provide the portfolio. Most of the work was great. Really happy with it. You got to know the technology, and that will stand you in good stead, because now when you do other subjects where you see as part of the course profile and the assessment obligation that you're required to complete and upload some audio visual, you know exactly what to do. What I would recommend is that you make a note to yourself of the procedures that you've adopted, so that if you find yourself under pressure needing to get this assessment done a year from now, you can look back at your notes and you've carefully guided yourself through the process. So it really is important when you're doing law, when you're practicing law, when you're studying law, to make sure that you leave yourself a crumb trail to follow in circumstances where you're under pressure in the future. All right, so we've got a few apologies tonight. We've got a few apologies. No microphone from Monique, and video. Are there any questions about the assessment that we've just done in intro, or the assessment that we're about to lodge in statutory interpretation, bearing in mind I have to be careful about the second one? Any questions, any comments? All good? All right, let's move on then. Okay, back to a basic. Legislation overrides case law. We know that. Can anyone tell me what the doctrine is that essentially says that? So if you're standing in front of a court and you say, well, the legislation overrides the case law, Your Honour, so what's your authority for that statement? Can anyone tell me that? No? Separation of powers? No. There's another doctrine. It's like separation of powers, but it's not the separation of powers doctrine. All right, it's the, going once, twice, three times, doctrine of parliamentary sovereignty. So just keep that in mind. Okay. And if you make a proposition to a court to the effect that the law of the federal parliament overrides the law of the state parliament, and the court says, well, what's your authority for that statement? What would you say? And you can unmute your microphone or use the chat facility. You're being very quiet. It's all too quiet out there tonight. You don't want me to pick on people, do you? No, not separation of powers. So why does federal law override state law? Think The Castle. Those of you that put in one of your favourite movies. It's not The Vibe. What's the authority? Constitution. Thank you, Alexander. What specific part of the Constitution? Can anyone tell me that? So if we're going to interpret legislation or we're going to do case law, we need to know some of these basics. All right, it's the Constitution. Why does federal law override state law? Section 109. Yeah, that deals with issues to do with the state, but not so much between the state and the Commonwealth. All right, here's some definite homework, not 15A. No. Okay, here's some homework. We've got to do this. This is an absolute must. You must have a look at Section 51 of the Constitution. And what you'll find is there are 40, I think it's 40, specific powers which are conferred upon the federal government, which is the basis upon which the federal government is able to make laws in the first place. And that is, if you like, the sovereignty in favour of, it's more than parliamentary sovereignty, it's the sovereignty of the federal parliament. Okay, so where do this, what laws then can state parliaments make? What areas of jurisdiction does state parliament have to make laws? Can anyone tell me? Section 51 of the Constitution, the federal Constitution, tells us what powers the Commonwealth has. What powers do the state parliaments have to make laws? Very quiet tonight. Yeah.
John, is that in relation to things such as police and emergency services and health and things like that?
Exactly. Great example. So when it comes to policing, we all know that we have federal police, but far more numerous in, obviously far more numerous is state police. So how do the state parliaments make laws that affect state police? Housing's another one, roads another one. These are all good examples. Education, well, education's a bit funny. It's a bit federal as well. But has anyone heard of constitutional challenges? All right, so we're aware of the Constitution. We're aware that the federal government has power under the Constitution. Have a look at Section 51. You'll see the 40, I think, enumerated powers. The simple answer, you'll kick yourself when I say this, is the states get everything else. All right, so the federal government has the power to make laws in relation to those provisions set out in Section 51. The states get the crumbs. And when it comes to interpreting statutes, sometimes there's a preliminary argument, a threshold argument, and that is, did the state have power to make that law in the first place? Did the Commonwealth have power to make that law in the first place? So where do you think these sorts of questions are answered? Let's say the Commonwealth government makes a law in relation to protecting the environment, and you look at Section 51 of the Act and you go through every one of those points and you say, aha, there's nothing in here that says the Commonwealth has power to make law in relation to the environment. Where do you think that sort of matter would be ultimately determined, whether the Commonwealth had power or not? Alexander is on fire tonight, the High Court. We're getting a few other High Courts coming in, but Alexander got it. So that's 2 to Alexander, 0 to the rest of the class. So come on, folks, we can catch him. But that's it. Oh, Susie, great answer. E.g. Tasmanian Dam case, which is exactly what I was leading to. So bear in mind that the Commonwealth has power to make laws in relation to Constitution, but sometimes they stretch the powers. And the way in which the Commonwealth made laws in the Tasmanian Dam case in the 80s was an example of where they used different powers to make laws in relation to, say, the environment. It might be that they rely on external affairs powers or powers in relation to companies or trade and commerce, and they kind of stretch it. So sometimes if we're looking at a constitutional issue and we're trying to decide whether the Commonwealth has power or not, be aware that the courts will need to consider whether the terms in Section 51 of the Constitution should be read narrowly or broadly. All right, what do I mean by a narrow interpretation of, say, the constitutional provision? What does that mean, a narrow provision, a narrow interpretation? You can unmute if you like. Anyone?
That means interpreting the legislation strictly as it is written without adding any other words in or assuming anything. Just, literal interpretation of the words of the legislation.
Excellent. No, I really like that answer. Thank you, Susie. Chantel had the same thing. So when we talk about a narrow interpretation, we're looking very tightly. An expansive or a broad interpretation is where we're willing to stretch the boundaries a bit in order to accommodate a certain, like the glasses at the tennis example. Yeah. Okay, so tell me this. If we have a tiering situation, we have state laws. Above state laws is Commonwealth laws. Is there anything, and we're talking statutes now, is there anything above Commonwealth laws? That's a tricky question. If we're going to deal with statutory interpretation, we need to know what statutes are. Alexander, international law. All right, so the score at the moment is Alexander 3, Susie 2. Others are yet to register. International law. Okay. So how does international law fit into this? How does international law come about as far as Australia is concerned? That's a broad question.
International law, we agree to be bound to it. It's not imposed on us automatically. We have to sign up with things like declarations and treaties and all that sort of stuff, like the Declaration of Human Rights. So we're not bound unless we agree to be bound by it.
Excellent. That is absolutely correct. If we agree to be bound to it, for example, we sign a treaty, does that then become Australian law? This is where you can get a point.
It has to be ratified into our own law, into our domestic law.
Yes. How's it ratified into our law? What's the process?
I think just normal legislation.
Spot on. Susie's got it. Yep, that's it. Does that make you 3 now, Susie? Yes. So just bear in mind that if we have signed an international treaty, that doesn't automatically become binding in Australian law. It must be incorporated into legislation in Australia. So we might sign an international treaty, protecting marine life, for example, but that's not going to be binding on Australian citizens unless and until Commonwealth Parliament makes legislation which reflects the obligation imposed upon it in the treaty. Okay, so these are all preliminary questions when it comes to the structure of our law, the hierarchy, and also, if you like, statutory interpretation in a broad sense. All right, are there any questions so far? No? Ali, I might get you to mute your microphone if you don't mind. Okay, unless, of course, anyone's got a question. Now, not every question or legal dispute can be decided purely by reference to legislation. I think that's right, isn't it? Can anyone tell me, then, 2 ways in which issues are determined other than by statute? That's a broad question. That's a precedent, yes, which is common law. That's a good answer, Shay. And what's the other way that we can determine the legal position other than by looking at a statute and other than by looking at the common law? You get a point for that, Shay. Case law, yeah, that's the same as precedent. Jay, I'm going to... Jury, no, Dakota, no, that'll be for crime. So we've got statute, yes, which is law made by Parliament. We've got case law and precedent, law made by the courts. What's another way in which law is made effective? Now, this is a really tricky one, but I'll give you a hint. Separation of powers. We've dealt with 2 of the 3. What's the third one? And that'll give you a hint. Not equity, not referendum. Delegated authority. Alexander, yes, that's it. Administrative. Chantel, close. What do we mean by delegated authority or administrative? Not QCAT? You might have to unmute and tell us, Alexander. No, not unmuting. All right. So, oh, yeah, sorry, Alexander. Yes. We can see that you've unmuted, but it's just not coming through. Sorry. That's all right. We'll continue. But that's right. Okay, so when we're talking in terms of statute, we have statutes that are made by Commonwealth, statutes that are made by states. Yes? We have common law, which may be separate to the statutes, or it may reflect an interpretation of statutes, but it's judge-made law. The third way is delegated legislation or delegated authority. This is where Parliament provides authority to the executive to make laws. So you've all heard of delegated legislation? I hope you have. We've talked about that. We've shown you where you can have a look at regulations, bylaws, rules. They're all examples of delegated legislation. People sometimes talk about it as second-tier legislation, but effectively, delegated legislation comes into effect when Parliament says, we now delegate to the executive power to make regulations with respect to this legislation. Okay, so let's take a sort of simple type scenario. Let's assume that Parliament says, we're tired of people speeding in our streets when they're driving a motor vehicle, so they pass the law, you're not allowed to speed in our streets Act. And there's one section and it says you're not allowed to speed in our streets. Second section, the only two sections, the second section says the Parliament delegates the authority to the executive to make regulations with respect to this Act. Then the Parliament is saying to the executive, to the administrative branch of government, all right, you fill in the detail, and then you'll get a regulation, and it says you're not allowed to speed in our streets Act regulation, and in that regulation it says if you're speeding, if you're doing more than 60, it'll be so many points. If you're doing more than 100, it'll be so many points and so many fines. So all that fine detail is part of delegated legislation. Now, why on earth would we do that? Bit quasi-judicial, yeah? Why on earth would we have delegated legislation in the first place? I'm looking for three reasons. Ministers may not have the experience or the knowledge. Yes. It's faster. Yep, that's good. Expediency in court. Yep.
I was going to say perhaps just spread some of the responsibility out as well, taking some of the heat off the parliaments to have to do everything.
Exactly, yep, thank you. That was Angelina. That's a good answer. So they're all good answers. Also, things change, don't they? Things become quite complex and it's more flexible, says Simon. Yep, they're all really good answers. I'm not giving you away any points on that one, mainly because I've lost track, but they're all correct. So I would recommend that you do some reading about delegated legislation to get an idea of what it means, when it comes into effect, and why we have it in the first place. All right. Now, we all know that to make statutes that we can then interpret, we need to have them passed, but originally they're known as bills and they go through a process to become acts. Yes, we all know that. When does an act become law? What's the sort of final process?
When it's commenced.
Yes.
The commencement date, which can be either the date of royal assent or it can be a date set by Parliament for the commencement of the Act.
Excellent. All right, so we're getting some really good answers there. Royal assent, when it's proclaimed, royal assent. Okay, so that's all very good, and I agree with all that. But where do we go to find out when an act is, when we do have royal assent, and are there any rules about royal assent in legislation? Let's think about Queensland to start with. Very good. We're getting some answers here that I wanted to see. Acts Interpretation Act. Thank you, Leonie. Thank you, Monique. What's the Acts Interpretation Act in Queensland? That's a fair hint. Yep, 28 days after, 1954. Okay, so the Acts Interpretation Act 1954 is the answer. I almost gave the complete answer to my own question. Thank you, Melissa. Thank you, Chantel. So, Acts Interpretation Act 1954, have a look at section 15, capital A of that Act, and it will give you some good information about the process of law becoming effective and the process of royal assent, or the assent of the Crown. Okay, Commonwealth. Do we have something like the Acts Interpretation Act at a Commonwealth level? 1901, exactly. Thank you very much. So we had a few quick answers there. So the Acts Interpretation Act is important in introduction to law because it tells us something about when legislation becomes effective. And the Acts Interpretation Acts are important in statutory interpretation because they tell us something about interpreting statutes. You'd think the subject statutory interpretation, the very first thing we do is plough through the Acts Interpretation Act, which we don't do, but we should. I would commend that you read the Acts Interpretations Acts, both federal and state, pretty carefully. Not every word, but there will certainly be some key sections that you want to have a look at. At the Commonwealth level, section 15 AA, state level by coincidence 15A, they just happen to be coincidental. Commonwealth, in terms of date of assent and the date of commencement of the Act, does anyone know the section in the Commonwealth Acts Interpretation Act that deals with the date of commencement of legislation? We know it's 15A for the state. No one? Chance to catch up to Alexandra and Susie. Not 51. No. So the Commonwealth Acts Interpretation Act, if you're really quick at Googling or going to Austlii, you'll be able to find this. I'll give you a hint. So what we're looking for is the section in the Acts Interpretation Act Commonwealth, which deals with the issue of the date of commencement of legislation. The answer is that if an act does not contain a date for commencement, this particular section says it is, yes, Leonie is right, commences 28 days after the date of assent. But what's the section of the Act that says that? 3A. Melissa, very good, you're on the board. So that's the one we wanted to see. So have a look at section 3A of the Acts Interpretation Act Commonwealth and generally become familiar with that legislation. It's really important that we do that. Look, one thing I always thought about when I read that legislation is that it talks about the Crown. What do we mean by the Crown? Can anyone tell me this?
The Governor General.
The Governor General is associated with the Crown. Governor General is not necessarily the Crown, but represents the Crown. The Queen's representative, the head of state. Yep, these are all right. But when we talk about the Crown owning land, or okay, let's do this example. Has anyone done property law or done conveyancing? We must have a conveyancer here, surely. I have a great admiration for conveyancers. I've said that often. Do we have a conveyancer? Do we have someone who works in a law office that deals with property? Do we have any solicitors?
My friend does. I think the Crown refers to the Commonwealth as a whole, yes?
The Crown, yeah. So let me say this. If you look at a title deed, which is proof of ownership of real estate, it'll have your name. If you've bought the land, for example, it'll have your name, but you don't own it 100%. Because if you look carefully at the fine print, there's a reservation, isn't there? And the reservation is to the Crown for certain things such as petroleum and mining rights. So just be aware of that. You might think that you own freehold means it's yours completely, but it is subject to a reservation in relation to mining rights or petroleum rights or whatever. Now, that reservation is in favour of the Crown. Does that mean the Governor-General? Not quite. The Governor-General is the face of the Crown, is the representative of the Queen, is the, if you like, the institutional person behind the Crown, but it's not really the Crown. Can anyone describe the Crown in the way that I'm searching for an explanation? I'm being cryptic tonight. The land itself, no. The state, which represents the Commonwealth, yes, maybe, kind of the people. In America, the Crown is really the people. Let me explain it to you this way. The Crown is not the government. That's the first thing. So we elect a government, don't we? And the governments come and go. So the Crown is not the government. The Crown is not the executive either. Exactly. It's not strictly the executive, but the Crown is like this. People in a family can come and go, can't they? So the family is, it might be mum and dad and 3 kids. And then, within the family, the kids go off. They're still part of the family, but they're not part of the household. So the Crown is like the household. It's always there. You don't really know exactly what it is, but it's always there. So, and, there might be in the household, there might be mum and dad and 1 child, or there might be mum, dad, 3 grandchildren. They're all kind of family, but the individuals come and go. But there's always this thing called the Crown, which is like the household in that sort of context. I hope that makes some sense, and it's the best I can come up with in terms of describing it to you. All right. We know, just on statutory interpretation now, those of you doing 11059, I expect you to come to the fore here. We've talked about purpose in terms of statutory interpretation. What's the starting point when it comes to interpreting statutes? What do courts always do first?
Look at the text.
What was that? Read the text?
Read the text, so the actual text of the...
Yep, I like that. So I'll take that as meaning the starting point is to look at the text, thank you, and then consider the ordinary meaning of the words. So we're looking at, look at the purpose of the mischief. Yeah, I think at the start we read it, and I think, and if we read it and there's an ordinary meaning, then that's what we always do. Is there something that says something about the way in which we read it in terms of its purpose at a Commonwealth level? Can anyone tell? I'll give you a hint. I'm looking for an answer from the Acts Interpretation Act, Commonwealth, which deals with the way in which we are to interpret legislation. Can anyone give me a section that I'm looking for in the Acts Interpretation Act, Commonwealth? 15AA. Thank you, Leonie. You get a star for that one. That's it. So 15AA says, capital A or double A. In interpreting a provision of an Act, the interpretation that would best achieve the purpose or object of the Act, whether or not that purpose is expressly stated, is preferred to each other interpretation. So that's the best achievement approach, which is reflected in section 15A of the Commonwealth legislation. Okay, so make sure that you're aware of that as, if you like, the starting point. We talked about the mischief rule, the purposive rule, the literal rule. They're all the common law approaches, but bear in mind that you've really got to check the legislation first whenever you're considering these things. And then those rules apply as well. Okay, just another quick thing for those doing statutory interpretation. Sorry for those of you doing intro only. You're probably wondering what I'm talking about when I talk about the literal rule, the golden rule, and the purposive rule. In fact, let's get someone to explain it. Let's have someone explain the literal rule. Alan, would you like to do that for us?
The literal rule takes the words of the Act literally in their stated form and interprets accordingly. So it's regarded as a very formal approach to interpreting the constituents of an Act.
Great. Thank you very much, Alan, for volunteering that information. Do we have a volunteer for the golden rule before I nominate someone? Someone from 11059. Yes, Jay?
Golden rule is it allows the judiciary leeway to interpret a phrase or term within an Act without actually using a literal approach. So you look at it in context of the purpose of the Act and trying to avoid absurd or a ridiculous result, which isn't really the purpose of that Act.
Yeah, that's good. Thanks, Jay. So the way I like to think of it is that the literal rule is where we start. We read it literally. Then a variation to that literal rule is the golden rule that says that's all very well, but we're not going to allow an absurd result. So that's the golden rule. So thank you to Alan, thank you to Jay. So can anyone tell me the final one, the mischief rule, or the modern approach is the purposive rule? What do we mean by that?
You consider that the mischief, what the mischief is that the legislation is intending to remedy, or the purpose of the legislation.
Exactly, and I couldn't see who that was. Sorry, Susie. Thank you very much, Susie.
Me.
Was it? Yeah, thank you. Excellent. All right, so those of you doing introduction to law and you're not doing statutory interpretation, I hope that's given you some insight into what we mean by the basic rules of statutory interpretation. All right, just a brief thing on extrinsic materials. Can anyone tell me if the issue of the way of extrinsic materials is used by courts is contained in legislation? Let's think about the Commonwealth legislation to start with. What legislation do you think it might be in, the way in which we use extrinsic materials? Is it the Extrinsic Materials Act?
I was going to say, I was thinking of extrinsic materials as things such as, because all I've done is look at this darn assessment for days on end, is things like second readings of bills and things like that outside of the legislation, not the intrinsic, like the little objects of the Act and definitions, etc.
Exactly, that's a great example of extrinsic material, a second reading speech or, you know, a report from Parliamentary Council. So they're the good examples of extrinsic materials. But what is the law, the statutory law, that we're getting some answers here. Acts Interpretation Act and Alexander's on the money 15AB of the Acts Interpretation Act is the one that I was looking for. So at common law, the rule was that extrinsic materials were not to be considered because they didn't represent necessarily the final opinion of Parliament. That was the common law approach, but that was regarded as being too restrictive. So Section 15 Cap A, Cap B of the Acts Interpretation Act Commonwealth was introduced to provide that those sorts of things are admissible when it comes to interpreting legislation. And when I say those sorts of things, that's dreadful language. I mean the admissibility of extrinsic materials. Melissa's given us one example, which is second reading speeches. Another is parliamentary debates, Hansard. Another is explanatory memorandums or reports by committees. Okay, so at common law, those things were not admissible as a way of explaining legislation, but that approach is now subject to 15AB of the Acts Interpretation Act. You're probably getting a bit of a theme tonight, and that is that I want you to read the Acts Interpretation Acts, both Commonwealth and State. I hope that's coming through pretty clearly. All right. Let's talk about something a bit more interesting. The statutory interpretation's all relatively when it comes to kind of interesting, isn't it? Does anyone know the difference between something that is exhaustive, a list that is exhaustive, and a list that is not exhaustive?
A list that's exhaustive covers every possible scenario or every possibility that there can be. A list that's not exhausted is more like a list of examples, and not every possibility is covered.
I like that answer. Thank you, Susie. And as you were speaking, Monique was coming in saying exhaustive includes everything. Leonie, detailed versus not detailed? Close. Is there such a thing as an exhaustive list, says Jay. Not exhaustive is suggestions or examples, and there could be others, says Monique. So, yeah, the answer I was looking for is this, that if we have a list, and we often see lists in legislation, don't we? You know, something means blah, 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 and a long list of things. Or it might be something includes blah, 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 and a long list of things. So we see that a lot. So when we talk about a list being exhaustive, what we're saying is it does include everything. That's it. When it's not exhaustive, we're saying it's these, but it could be others. It's not exhaustive, the list. It could be others. So you need to understand that terminology, because when you're on your feet, a judge or a magistrate may say, well, yes, I understand what you're saying, but isn't that an exhaustive list? Ms. Lowry or Ms. Kenny, isn't that an exhaustive list? So you've got to be prepared to answer that and know what exhaustive means. So let's have a look at some actual words that we see in legislation. If we have a long list, if we have a definition in a piece of legislation, it might say something means A, B, C, and D. By using the word means, do you reckon that means, sorry, does that suggest to you that the list A, B, C, D, E is exhaustive? Yes, we're getting some nods. Okay. Yes, ordinarily. Ordinarily. I like that word, ordinarily, Chantel, but yes, yes, yes. So if we get that list, you know, means, what if we get a list, what if we get a definition that says something, ... sorry, something includes A, B, C, and D. Is that exhaustive? No. Good. No, not exhaustive. All right. So a basic rule is that if you see an interpretation, a definition within a statute, and the legislation uses the word means, it's exhaustive. If the legislation says includes, it's not exhaustive. But that's not always the case. Don't you hate it when it's not always the case? All right, let's take a real life example. This is from, and you can have a look at this case if you like, it's RV MCN. I think that's right. It's 1963. 63 State Reports New South Wales 186. Okay, so 1963, 63 State Reports New South Wales 186. New South Wales Court of Appeal, 3 judges. They had to decide whether illegally driving a double-decker bus was constituted the offence of illegally driving a vehicle. So essentially, is a bus, a double-decker bus, a vehicle? Now, the Crimes Act provided that a vehicle includes a cart, wagon, carriage, aeroplane, or other aircraft, motor lorry, motor or other bicycle. Question is a double-decker bus covered within that section, and therefore, if it is, the defendant is guilty? Do you want me to read that again, or did you catch that? So, was the defendant, all right, so yes again. Okay, so here's the such scenario. Someone's pulled over illegally driving a double-decker bus, charged for illegally driving a vehicle. Forget the context, but the real case comes down to this. The legislation said a vehicle includes a cart, wagon, carriage, aeroplane or aircraft, or other bicycle. He said, well, I'm driving a bus. That wasn't mentioned in the definition, so I'm not guilty.
So it's not exhaustive.
It's not exhaustive, says Shay. Bus isn't covered. That's right, Susie. Bus is not covered, which is the defence.
But it could be so. It could be that broader. It could be a broader interpretation of that, because it's not exhaustive. Because if it's exhaustive, it was means, and then it would include all the vehicles. But because it was includes or only listed a few, that it could be a broader term.
Yep, and I think that's right. Yeah, sorry.
I was just going to say, isn't this where they'd turn to the mischief rule?
Yes, and that is always on the cards when they consider the purpose. If you were considering the purpose at a state level, at a federal level, you'd also consider Section 15AA, wouldn't you? And Shireen says the purpose of Parliament could be used. So I agree with all of that. And you're right, when we talk about something that says includes, it's not exhaustive. That's the starting point. In that case, 2 judges said the definition was not exhaustive and bus fell within the ordinary meaning of vehicle. Now, here's the part where I said it's not always the case, because the 3rd judge says the definition was exhaustive, despite the fact that it said includes. The 3rd judge got round that by saying that the charge could be sustained because a motor car includes a bus. It was wide enough to do that. So that's all I want to say about exhaustive versus not exhaustive. I hope you're not exhausted as a result of all that discussion. We doing okay? Thumbs up? Okay. We'll keep going. Thank you. I've got a lot to cover tonight. I'm not going to get anywhere near where I wanted to get to tonight. I'm sorry. But I need to talk about some sort of more general things as well. I was actually going to give you a redrafting exercise tonight, but we won't have time. I like doing that. We will do that at some stage. I may even have another joint session for the specific purpose of doing a redrafting exercise. You see, just to give you an idea of what I mean by that, it's now the law that we draft in simple manner, in plain English. Yeah. And I say that it's the law because that's the way in which you're supposed to do things. Have a look at the Office of Parliamentary Counsel, and it refers to active encouragement of the use of plain language in developing legislation. So part of the exercise tonight that we won't have time to do, we'll do it later, was actually getting you to draft something. So we'll do that some other time. But in the meantime, if you want to prepare for that, have a look at the Office of the Parliamentary Counsel, which talks about the use of plain language in developing legislation. All right, so we'll come back to more general things. Bit of an extra all the bits and pieces thing tonight. Can anyone tell me the monetary limit for litigation in the Supreme Court in Queensland. Is there a monetary limit? For example, if you're litigating over $5 million, do you have to go to the High Court for that, or can you stay in the Supreme Court? So what's the monetary... I'll go the other way. We'll start the other way. What's the monetary limit for the Magistrates Court? Can you sue someone for $5 million in the Magistrates Court? What's the monetary limit? Oh, I'm getting a lot of different answers. I'm getting 150, 10, these are thousands, 20, 75, 150, 150, 25. All right, by on a close thing, 150, we're getting another vote for 150. All right, the answer is 150. That's the current monetary limit in the gone at 150. Exactly right, Jay. So 150 is the monetary limit in the Magistrates Court. On the buzzers, what's the monetary limit for the District Court? Getting a few answers coming through. In thousands, we're getting answers that say, need a few more yet. 500, 750, 750, 750. Someone's given us a website link. That's very clever, Angelina. 750. All right, it's going at 750. 750 is the monetary limit for the District Court. Back to the original question. What's the monetary limit for the Supreme Court? Anyone? Monetary limit for the Supreme Court. Oh, that was right. Thanks, Angelina. Angelina gave the plain English manual from the Parliamentary Council. Adam says there is none, question mark. Is that an answer or a question, Adam?
Isn't it greater than 750?
Greater than 750 is an answer. No limit is another answer. It's in the millions is another answer. We're getting a few different versions here. The most common answer we're getting is there is no limit. And that's the correct answer. So in the Supreme Court in Queensland, there is no monetary limit. What's the monetary limit in QCAT, which is, of course, very near to my heart? Monetary limit in QCAT, we're getting 20, 50, it's going up, 25, it's going down again, 25. All right, it's a trick question this, because there are two limits in QCAT. There's the limit for minor debts jurisdiction, and that is 25. What's the monetary limit for anything in QCAT that is not a minor debt? So it might be, for example, a domestic building dispute. Can you sue someone for $1.5 million for a building dispute, domestic building dispute in QCAT? All right, the answers are 750, no. I haven't seen the right answer yet. This will surprise you. The answer is unlimited. So if it's a matter which within the jurisdictional type in QCAT and it's not a minor debt, then it is unlimited. All right, enough of that. Let's move on to something a bit different. Can anyone tell me the two types of court process? I'll give you a hint. One is inquisitorial. What's the opposite of inquisitorial? Adversarial. Thank you very much, Melissa. Susie just got beaten by Melissa. Well done. That's it. Do we all know the difference between the two? Yes? All right. So what type of litigation do we have? Fast typers. What type of litigation predominantly applies in Queensland litigation? Adversarial or inquisitorial? We're getting some answers saying adversarial. Yep, and that's right. Not always. In some jurisdictions, in tribunals, sometimes it's inquisitorial, but mostly it's adversarial. Okay. All right, some other quick questions, and I know it's all a lot of mixture tonight. You're at a social event and someone introduces you to a district court judge. What's the correct or the generally accepted correct address to a district court judge at a social event where you want to ask a question? Do you say, hey, you, or do you say something different? We're getting a mixture. Judge is getting 3 votes, 4 votes. Your Honour is getting just as many. It's line ball. We're getting a justice. G'day is not the answer, Melissa. All right. There are different schools of thought. My personal view is it's judge. So that's what I do. If I'm at a social event, for example, and I'm speaking to a judge, or I'm greeting a judge, or I wish to ask a question of a judge, then it will be judge. But you can use Your Honour. That's what we use in court. To me, that's a little more formal than we need to do in a social context. The reason I'm telling you this is that if you're going to be part of the profession, you want to fit in and you want to feel confident that you can fit in. And you need to know some of these little protocols that are important. And if you don't get it right, it's kind of a giveaway. So I'll go with judge. What about a magistrate in a social event? What would you call? Rebecca asked the exact question just before I asked it. I didn't see your question there, Rebecca, but that's right. So how do you address a magistrate in a social event? Anyone? Sir? Yep. Very formal, but you can't go too far wrong with that, unless, of course, it's madam. That would get you in trouble. Your Honour, yeah, as a 4-bar, yeah, you could do that. All right, well, I tell you what I do is Mr. or Miss, Mr. or Mrs. or Ms. is really it. But I think I'm allowed to say this on a recorded video that everyone can see. You do get to a certain stage in the profession, if you've been around long enough, that many of the magistrates and indeed judges invite you to address them by their first name. So you would never presume that. But if you are invited to address a member of the judiciary by his or her first name, then it's perfectly proper to do that. But sometimes you do it with some circumspection. For example, if a magistrate or a judge does invite you to use a first name, then you might do that selectively, perhaps at a social event surrounded by colleagues, or in chambers where it's a private situation, but you wouldn't necessarily do that in a courtroom, even if the court is not constituted. If the judge just happens to walk in, I wouldn't use a first name then. But generally speaking, for a magistrate, Mr. or Mrs. Okay, you've been very patient with me tonight. I'm nowhere near finished where I wanted to get to, but we probably better wrap it up. People have lives. I appreciate that. Are there any questions that you want to ask me tonight about our mixture of bits and pieces? All good?
John, can I just ask, with the assessment we just that's due today, should we not obviously be too concerned about our turn-it-in percentage, given that, would we expect it to be a little bit high considering we're half and half roughly of who's doing what case and we're all saying the same stuff? Well, I hope we're all saying the same stuff.
Look, honestly, don't worry too much about the turn-it-in percentage. That can be very high and you haven't committed plagiarism at all. Alternatively, it can be quite low and you have committed plagiarism. I'm sure you'll be fine. I won't mention who it is. But it really is a matter of identifying if you've sourced material externally. Just acknowledge it, and you'll never go wrong. So there's no hard and fast rules on that. But good question. Thank you. Now, was there another question?
It wasn't a question. John said that that it was very helpful tonight's session. It was really good for what we've been doing.
Thank you. And Rebecca, that was 11059 that Melissa was talking about. Yeah, I just thought we'd try and break it up a little bit tonight and do something a bit different. Okay.
John, can I
yes.
just ask, are you a 2-week turnaround as well, or are you sort of do it all at one time, or are you sort of filtering out to the people that you mark as you go? How do you...
Oh, okay. No, that's a good question. I didn't catch who that was. Sorry.
That's Leonie.
Oh, hi, Leonie. Look, my process is always the same for work that requires provision during the semester. It's always the same. My assignments are always due at 11:45 p.m. on a Thursday. I insist that you submit your work by no later than 11:45 p.m. on the Saturday week. So that's 9 days later. If you happen to get an extension from me, which is tough, it's very hard to get an extension out of me, but if you happen to get an extension out of me, let's say for 2 days, that does not extend the final cutoff. It's still the Saturday. And the reason I do that is that it's very important that I give feedback to students as quickly as I can. And what I typically do is on the Saturday, the Sunday, and the Monday, if I need to, that's when I do my marking for the most part. And what I then do is I release all the marks at the same time. So I might do some progressive comments. You probably wouldn't be able to access those. Maybe you can. I don't think so. But the actual marks I go through in one hit and release them all together. So I hope that answers your question. Any other questions or comments? All right. Well, look, thank you very much for attending tonight. Really good that we had a good roll-up. And we are back to the normal times next week. I appreciate it's late in the year, but we are on for next Thursday. So we'll look forward to seeing you all then. I'll stop the recording and we'll end the session. 6 o'clock and 7 o'clock for the 2 subjects. Back to the normal times. Okay, see you then. Bye.